first of all, good morning and good afternoon, friends and colleagues of PDA. You can hear me? Yes, thank you so much. I am Margareta Cederfelt and I'm president of PDA and member of the Swedish Parliament. And I am very delighted to welcome all of you to this webinar. Tomorrow, there will be the 18-word day against death penalty. And despite the complicated circumstances we find ourselves in this year, it warms my heart to see the abolitionist community rallying once again to say loud and clear that the death penalty has no place in the justice system. The theme for Word Day this year is the right to effective legal representation and the devastating consequences its denial has in capital cases. PDA, who has been mobilizing its members against capital punishment since 2013, has produced with the World Coalition Against the Death Penalty in Parliamentary Factsheet on the death penalty and access to effective legal representation, which aims to explain what the right to effective legal representation is and what concrete actions parliamentarians can take to address these issues. And we hope this tool will be useful to all legislators, whether they are already convinced abolition or not. And for me, this is a very important issue. As parliamentarian, one of our most important issues is, of course, to represent our constituency, but it's also to look after that rule of law is followed, that all people have the right to stand in front of the law and that life is respected. And when it comes to death penalty, it's non-reversible. When it's there, it's not possible to go back in time. And that's why it's so important for us to work against death penalty. To discuss this very interesting and important topic, I am pleased to introduce two remarkable panelists. First, Mr. Parvaris Jabbar, who will share with us his experience as a lawyer defending individuals facing the death penalty in various countries. Parvaris is the co-founder and co-executive director of the Death Penalty Project and has over 25 years of experience representing individuals facing the death penalty around the world at the appellate level and before international bodies. And after that, I am very proud to announce that our dear friend, Honorable Kasturi Patu, who is a member of the Malaysian Dewan Rakyat and also a member of the PDA Executive Committee. Kasturi has been a very engaged parliamentarian since 2013 and has relentlessly promoting abolition of the death penalty and in our own country and throughout the world, including by acting as convener of PDA's campaign for the abolition of the death penalty, which is a part of the PDA International Law and Human Rights Program. As president of the PDA, I warmly thank them both for putting some time aside for this event and for their contribution to the promotion of abolition of the death penalty. I also want to thank all the members of the World Coalition, which has been a close partner of PDA for many years, for all the hard work done ahead of the World Day. And also thank you for all of you attending the launch of the fact sheet. And I wish you all a fruitful discussions. And I do by myself very much look forward to this important seminar. And by this, I will hand back the floor to Marion Chachunio from PDA. Thank you very much.
Thank you, Margareta. And without much further ado, I'm just leaving the floor to Parve.
Thank you, Marion, and thank you, Margareta, for the introductions. Good morning. I'm just going to see if I can share with you the PowerPoint presentation. I don't think it's that. Just give me 1 second. Sorry, this is the problems of technology.
I think everyone knows how Zoom goes now.
Maren, has the PowerPoint come up?
Not yet, no.
Okay, 1 sec. It was working earlier. I'm not quite sure why it's not working now. 1 second. Sorry about this. Perhaps I can't really share it. Maybe I'll just let me see why it's not working. I'm really sorry, Marion. For some reason now it's not.
If you want, you can send it to me and then I will put it on, and then you just start and then I'll put it on a little bit afterwards.
Okay, so I'll just send it to you as an email now, yeah?
Yeah, okay.
I'm not quite sure what's happening. Perhaps to make it easier, perhaps maybe Kasturi could start, and then maybe once I get this fixed, I can follow Kasturi. Is that okay, Kasturi?
Yeah, that's fine.
It might be easier if we just get this sorted out while you're speaking.
All right. I was actually hoping to comment on your fact sheet.
Okay,
and your...
well, let me start. Sorry, forgive me. Let me start then. Let me start, and I'll just send this to Marion now. For some reason, I don't know why isn't doing it. But perhaps Marion, perhaps I can speak, and then, as you say, what I can do is maybe share the PowerPoint presentation, which you can circulate to others.
Yes, of course.
Okay, well, good morning, everybody. Forgive me, I'm so sorry about the delay. And thank you to the PGA for inviting me to address this on this panel on this very important event marking the 18th World Day Against the Death Penalty. I'm very privileged to be asked to speak, albeit virtually. And I know that the organisers are very keen to ensure that we have as much engagement as possible, so we can hear the thoughts and views of those who are participating today. So I'll try to keep my submissions and comments reasonably brief. As was said during the introduction, I'm the co-executive director of the Death Penalty Project. We are an international legal NGO working to promote and protect the human rights of those facing the death penalty. We work in a number of ways. We provide legal assistance, we train and capacity build for stakeholders within the criminal justice system, lawyers, judges, prosecutors, and we carry out and commission research on issues around the death penalty. But we also engage with governments and politicians in those countries that have capital punishment and are looking to move away from this practice. So in the main, we provide pro bono legal assistance at the appellate level once somebody has been convicted. And this really involves appeals to both national courts of appeal and international tribunals. And in some of those jurisdictions that retain final appeals to the Judicial Committee of the Privy Council in London, we provide full legal representation as the advocates, together with local counsel from that country. And this you would find mainly in countries from the Commonwealth Caribbean. In other jurisdictions, like countries from Anglophone Africa, South and Southeast Asia, we seek to restrict and advise, seek to assist and advise individuals and their lawyers in appeals against conviction and sentence before local courts of appeal. So really we work across the world and have experience engaging and working in many of the retentionist countries where capital punishment is practiced. Now, in terms of legal advocacy, our work really involves a mixture of criminal and constitutional litigation, where the safety of the conviction or the imposition of the sentence will be challenged. And what we try to do is we try to highlight miscarriages of justice in individual cases, and through that jurisprudence, we seek to develop the law, because they are mainly common law systems. So case law plays a very important role, and we hope that can restrict and limit the scope and application of the death penalty. So my aim really in the short time that I have is just to say something about the issue of access to justice and legal assistance in death penalty cases, and to highlight both from really an observational point of view and also through our own experiences, some of the problems that we see that exist. And of course, not every issue that I raise is relevant to each and every jurisdiction, but there are certainly similarities and certainly general patterns. The first thing worth mentioning is the issue about representation in capital cases. Issues concerning the quality of legal representation in criminal cases is a very serious issue. Legal representation in capital cases even more so. And that's really because the very nature of the offence, considered a most serious offence, and the very nature of the resulting sentence and its obvious irreversibility. So for this very reason, there is a need to have an even more rigorous attitude to this area on the ground that death and the death penalty is what has been called special, and that what is required has been termed as even more heightened scrutiny over and above usual standards because the case is capital. And you will see many of the best practice guidelines that are often articulated by legal groups are done so as a reflection of the need to ensure minimum standards in legal representation that can be adopted and applied throughout. Standard setting measures, I think, are very important. They create uniformity and minimum guidelines, and in turn, what they do is they provide a very valuable safeguard to ensure protection in each and every case, and it's something that can be assessed in each and every case as well. So I think it's important to look at the issue of legal representation in two ways. First, it's important to appreciate what, if any, what I would call institutional obstacles. So really we're talking there about systems and systemic issues. What obstacles exist which can hamper the very role of the advocate in providing effective legal assistance. And the second main issue relates to the limitation of the lawyers themselves who are providing that legal representation. And my view really is that the second issue is exacerbated and aggravated, but also very much intrinsically linked to the first issue, that issue of institutional and systemic obstacles. And I think there is a very strong and critical need to improve the institutional defects, which I think will in turn improve the very standards of legal representation themselves. So what are these institutional obstacles? It's easy, obviously, and very simple sometimes, just to explain inadequate representation by reference to the conduct of the lawyer himself or herself. In some cases, this is obviously true, but in the majority of cases, a better context, I think, is required to fully explain the problems. One of the main problems is the issue about inadequate legal aid and assistance. So in many of the jurisdictions in which the death penalty is imposed, whilst there are a very large number of talented advocates who work extremely hard to provide the very best possible representation, one of the most important restrictions that exists to frustrate the role of the advocate concerns the inadequate provision of legal aid and assistance. Legal aid, for example, in the Commonwealth Caribbean, where we work, and many parts of Anglophone Africa, are at times shockingly low, if not non-existent. legal aid can only be sometimes provided in very serious cases such as capital offences, so it isn't universal, but in some jurisdictions they are limited to what are commonly called Crown or court briefs, where counsel themselves are asked to assist the court on very, very, very low rates, very fixed rates, because defendants are indigent. So one example I can give you is the situation in Kenya. Capital robbery cases, for example, until very recently they were mandatory death sentences, were heard before a magistrate, and a defendant would likely be unrepresented at that trial. And the majority of prisoners under sentence of death in Kenya, which are in their thousands, are not actually homicide offences, considered the most serious offences, but simple robbery cases, or certainly they would be considered simple robbery cases in jurisdictions like my own in the United Kingdom. So, for example, an issue like stealing a mobile phone, because they involve what are considered to be aggravating ingredients, such as the possession of a weapon or involvement of more than one person, but involve no physical harm, they are considered capital crimes. So what you find in Kenya are large numbers of persons under sentence of death for crimes where there has been no fatal or fatal harm or injury. And in many jurisdictions I have worked in over the years, it is not uncommon for counsel to be provided with a fixed rate for representing an individual, regardless of whether the case lasts for 1 day or 1 month. And this obviously impacts the level of representation in some cases. And what you do find are that senior or experienced counsel are not prepared to be involved in those matters. So as a result, it is possible that a case with the most serious charge, for example, that of murder, and the most serious sentence, that of death, is often conducted by an advocate who may only have recently been called to the bar or may only be doing their first case. And that, of course, if you look at the example in the United Kingdom, it is the exact opposite of what would happen here. In the United Kingdom, it is usually what we call Queen's Counsel or senior counsel who will conduct murder trials with the assistance of junior counsel. Another aggravating feature we see is the lack of provision for legal assistance for what we call constitutional motions and actions. And this obviously affects the frequency in which lawyers employ constitutional challenges throughout proceedings to enforce constitutional rights and protections for the defendant. Constitutional challenges, we know, have an important part to play in the development of standards of due process and protection of law rights. This has been addressed by a number of international tribunals. For example, the United Nations Human Rights Committee has consistently held that state parties to the International Covenant on Civil and Political Rights, for example, have an obligation to ensure that constitutional remedies are not only available, but are actually effective. So this means, for example, a denial of legal aid to pursue an application, which might raise a violation of a fair trial right, would be a violation of Article 14 of the Iccpr. Another institutional limitation we see is the lack of legal or the limited pool of specialist advocates. And we see this in the lack of legal training and continuing professional development to ensure the establishment of best practices. So many lawyers in the jurisdictions in which we operate may actually work as self-employed practitioners conducting multiple disciplines. And a consequence of this in some countries is that access to specialized criminal practitioners simply does not exist. Again, this is more to do with structural deficiencies and the need for lawyers to be multidisciplined to earn an adequate living. In some jurisdictions, we also see the limited legal aid provided that will have an impact on the use of that legal aid provision by lawyers to pay for medical experts or investigations that they wish to carry out. No further provision is allowed, so that fixed amount is to be used for all investigations, and it can result in the limited use of experts by the defence. So that what you can see, for example, is that the state itself will have access to both its own experts and all the support resource structures connected to it. And this clearly would violate the principle of equality of arms and can result in a diminishing role of the lawyer, and maybe one important reason why fresh evidence, for example, that is crucial to a case is not put forward. Linked to that, of course, is the fact that in some jurisdictions there are very few suitably qualified experts who can actually be instructed by the defence. In some places that we operate in, we see that there are very few psychiatrists, for example, or in fact no forensic psychiatrists whatsoever in the whole of the country. And these persons, and the persons that do exist, actually may be employed by the state, meaning that only a state-appointed expert can be used by the defence. So there are no independent experts to go to. So really, the issue of inadequate legal aid provisions, the unavailability of experts, and the level of legal expertise in the pool of lawyers, these can all be considered, I think, as imposed institutional limitations which increase the likelihood that defendants charged with serious offences will be convicted and sentenced to death. Let me just mention a number of other sort of wider issues. There is also the issue of long delays in the criminal justice process. Many systems in which capital punishment remain part of the law are inefficient, they're ineffective, and at times they're incompetent. Evidence is compromised, witnesses are not available, and confession evidence is routinely obtained without the minimum standards of recordings, either visual or audio. So these create additional problems for advocates, and the long delays in the criminal justice process can also be exacerbated by long pre-trial detention, which mean that prisoners are often held in inhumane conditions of confinement for long periods of time. I mean, I should say, criminal justice systems in many, not all, are resource poor. And this is obviously most prevalent in developing countries, but allocation of resources can also cause similar issues in countries that don't have the same national deficit. So for example, we have seen countries like Malawi in East Africa, where external funding is required to actually fund criminal courts. And without that funding, cases cannot be heard and courts cannot operate. In more developed countries, we're increasingly seeing the erosion of legal aid or public defender systems, leading to fragile structures or the draining of talent into private or better resourced areas of the law. So whether it's a question of resources due to financial issues or questions relating to policy implications, these all add to the problem in ensuring effective legal redress. Another feature is that what you see in some jurisdictions is that legal systems have failed to modernize or continue to implement outdated practices. One stark example of this is the continued use of mandatory death sentencing upon conviction. And again, this is found in many of the Commonwealth jurisdictions in which we work. But not only for intentional homicide, but in some jurisdictions, such as Malaysia, where Kasturi is from, for drug and robbery crimes, not considered most serious crimes. And what has happened is that this practice has led to many people being sentenced to death because there is no alternative sentence that is allowed. And as I said, Honourable Pato will be speaking after me, and I'm sure she will say something about the Malaysian experience and reforms to change this. For myself, I remember I had the privilege to address the Malaysian Parliament a few years ago, the previous government, when they were considering abolition of the mandatory death penalty for drugs. And whilst it was a welcome development, what I found really interesting was that no moratorium was actually implemented whilst there were discussions to have these positive moves to change the law. So whilst we were discussing the issue of reform, executions were still happening, and thankfully, as I understand it, this is no longer the case. But the importance of raising the issue about sentencing regimes is that they create themselves procedural irregularities. So for example, in countries in Southeast Asia that impose a more automatic sentencing for drug-related offences and other drug offences over a certain amount, what it actually means is that the person who actually decides whether a person lives or dies is the prosecutor bringing that case. So by exercising prosecutorial discretion, they are the ones who inevitably decide the exact charge, which can mean the difference between a death sentence and a term of imprisonment. And it's really what's led to what academics in Singapore and other jurisdictions have described as the 14.99 rule, where defendants are charged in this way to actually avoid being given an automatic sentence of death. There is also the issue about post-conviction due process rights. The application of clemency and mercy, it's an important avenue of redress, and in some cases, it's the last opportunity to avoid execution. And whilst it's an executive act, the prerogative of mercy to be effective and available may at times require legal assistance. And many prisoners facing execution may not be aware of this opportunity and may not have the necessary education to bring a petition themselves. And many defendants are actually unable to read and write. So how they are able to bring an application for mercy or a petition for mercy is quite hard to fathom. And the right to seek pardon is a fundamental right. It's part of the protection of law rights. And the ability to do this might require the use of legal assistance. And again, you might see this in the ability to bring forward, for example, fresh evidence issues after the exhaustion of all domestic appeals. It requires not only a procedure, but also access to a lawyer to advise, action any legal challenge. One final feature in relation to the institutional obstacles I want to mention concerns the importance of signing and ratifying international treaties like the Iccpr, and importantly enforcing or applying recommendations of these bodies. This is a very important step in creating and applying standards universally, and countries, if they are committed to administering best practices, should really try to adhere to these international norms. That is why it's so important that standards are so important, because they help to provide a universal approach to due process and administration of justice. So these are quite, it's quite a lot that I've set out, but I'm trying to give a kind of a flavour of some of the institutional obstacles. What about the second limitation, that of the lawyer? The issue of ineffective or incompetent legal assistance. This can obviously lead to miscarriages of justice, but it's only fair to say that in all jurisdictions, there will be a number of lawyers who fail to meet the required standards in terms of legal representation, whether it's in the United Kingdom or a small country in West Africa or Asia. However, where countries retain the death penalty, the role of the advocate requires higher expectations simply because the death penalty is so serious. And whilst it's unfair to generalize, let me just give you one example of a case that we did a few years ago of a woman that we represented in Trinidad who had been sentenced to death for killing her husband by poisoning him. She had suffered years of abuse by him for many years. At her appeal, a fresh trial was ordered because of the inclusion of statements which she had given that ought to have been excluded, because this evidence had actually been obtained by the police officers, where evidence came to light that she had been sexually abused by the police officers during the investigation. She was convicted at the retrial, and the Court of Appeal upheld that conviction. We represented her in her second appeal and final appeal to the Privy Council. it was clear when we started working on the case that the lawyer had failed to take any detailed instructions from the defendant, and in fact was not even aware of her previous evidence. And it was only at the end of the prosecution case in the retrial, so a week into the trial, that he actually even became aware that he was involved in a retrial. I mean, it was quite amazing, really. And in this case, the courts found that the breaches of counsel's duty was of such a fundamental nature that the defendant was deprived of due process. And the judges said they described counsel's multiple failures as either revealing either gross incompetence or a complete cynical dereliction of the most elementary professional duties. And they described it as the very worst case of failure of counsel that they have ever come across. And it was very strong criticism. And of course, this is a very extreme example, but nevertheless, it's important to highlight what can happen if there is a failure to ensure effective legal assistance. But I want to stress that this issue cannot be disconnected from the institutional limitations that I've mentioned earlier, because they go very much hand in hand. But the importance of bringing these cases before court serves not only to highlight miscarriages of justice, but also to identify deficiencies in the system to bring increased vigilance in future cases. And these cases and other cases, they help to establish the principle that where there is a fundamental flaw in the conduct of a trial, any resulting conviction which results from it cannot be allowed to stand because of an automatic miscarriage of justice, regardless of innocence or guilt, because that person has not enjoyed the benefit of due process. And this issue of due process can be extended to many issues. It can be extended to the issues of disclosure, for example, when medical evidence has not been provided by defense counsel, by the state or arms of the state, and the role of and conduct of prosecution counsel, who really should be acting as a minister of justice in those proceedings. And they must act in a fair and balanced manner and not seek to frustrate the role of the lawyer. So the role of the prosecutor should not be minimized. Another feature that we have seen is the role of lawyers in failing to identify potential defenses, which can also be linked to the use of medical experts and those institutional limitations. So it's very important that lawyers identify at the very early stage potential medical issues or potential grounds that may provide either full or partial defences, resulting in acquittal or reduction of the offence from murder to manslaughter. And the importance of lawyers in understanding potential constitutional grounds that can be raised. Again, I mentioned the lack of legal aid for constitutional motions, which means that lawyers may not bring these issues, but also they do suffer from sometimes the inability to identify constitutional breaches. And this can only be improved by more legal training and so on. Another feature that I do want to mention are the role lawyers play in identifying and understanding changes in the law. I talked about the introduction or the abolition of mandatory death sentencing and the introduction of discretion, for example. This involves a change of the law where lawyers may not have been involved previously. The mitigation exercise in a capital case, for example, at the sentencing stage. It's important for counsel to be able to understand these changes and to apply and adopt changes in the law to ensure that prisoners or persons are no longer sentenced to death. Again, competency of counsel at this stage is therefore very, very important. And one final feature in relation to the issue of the conduct of counsel is the wider issues, sort of issues concerning political and social pressures. So whilst I've spoken about institutional problems and individual failures, there can be other problems that we need to address. For example, in smaller countries or tight-knit communities, a murder or heinous crime can affect many people. Public outrage, in some cases, can cause politicization of the offence and can make the work of the lawyer appointed to represent the accused very, very difficult. And sometimes lawyers can be at personal risk for representing a defendant who has committed a serious crime. Equally, in other countries, we've seen counsel who represent defendants facing the death penalty, maybe facing sanction and punishment if they are seen to be overzealous in their defence of the clients, or excessive in probing some of the evidence against them. So all of these issues will obviously have an impact on counsel and the client's chances of acquittal. So we have to be careful when we talk about counsel's failures, because there are other pressures involved, and it's very much the responsibility of the executive branch as well as domestic professional bodies who have a duty to ensure that practitioners do not feel threatened simply for carrying out their professional duties. I mentioned earlier the issue about standards. One of the important elements of constitutions is that they set out fundamental rights and embody general rights concerning protections of the law. And similarly, international bodies over the years have articulated these rights and how they should be interpreted. And it's the adoption of these standards, such as standards you see in the International Covenant on Civil and Political Rights. These set out very important standards relating to issues about the time of arrest, the right to be provided access to a lawyer throughout all stages, all pre-trial rights, but also minimum fair trial guarantees, which involve the rights to adequate time and facilities to prepare a defence. They include the right for counsel to be appointed at all stages of proceedings and the right to obtain independent experts. So when these standards are applied in every case, they should be adopted as a minimum, and they will provide better protection to defendants and better access to effective legal representation. So let me just conclude by just raising what I think are some important steps and actions. I think it's important to adopt minimum standards that should be applied across jurisdictions. Domestic legal associations have an important role to play here, and governments must engage with domestic associations in trying to adopt these minimum standards. I think it's important that governments and legislators recognise the importance of levelling up to provide equality of arms, both in terms of resource and in terms of practice. Issues around training and continued professional development of all criminal justice actors, lawyers, prosecutors, members of the judiciary. It's important because they provide best practice guidelines, but they also help to sensitise on important issues like capital punishment and its administration. And I also think it's important when lawyers seek to bring constitutional challenges on issues such as the provision of legal aid, fair trial rights, to establish minimum safeguards to be adopted in capital cases. And I also think we must seek to create legal networks, both within jurisdictions and regionally, to provide support and advice to members of the association. And let me just finish by saying why I think all of this is important. Ultimately, we should all be interested in this to avoid the risk of wrongful convictions and innocent people being executed. I don't think anybody would say it is acceptable to execute an innocent person. And we know from empirical research and from our own experiences working in NGOs as practitioners, as legislators, we know that death rows are disproportionately represented by those who are considered poor, marginalised and disadvantaged. Providing resources to ensure effective legal assistance creates confidence in the system from the general public, which is very important in giving legitimacy. And the experience of countries like the US, for example, which are resource rich, provide stark evidence that even in developed systems, wrongful convictions will happen and innocent persons executed. History has clearly shown that criminal justice systems are fallible and human error is inevitable. So whilst we strive to improve the defects, we know that mistakes will happen. And let me end by saying this. If it is the case that standards prove difficult to achieve for whatever reason, then we must question whether the death penalty should continue as a legal sanction in any civilized and modern criminal justice system, and accept abolition may be the only acceptable alternative. Thank you very much.
Thank you, Brian. Castery, if you want to react.
Yeah, is it clear? Okay, good morning to my fellow colleagues, to Marian, to Parvez, and also to Margareta, who was with us just now. Good afternoon to my friends back here in Malaysia. I'm Kasturi, MP for Batu Kawan, and also I'm in the PGA Executive Council. It's indeed a privilege to be able to speak about this very, very important subject at a time of a global pandemic. And also, I'm honored to be given the chance to speak after Mr. Parvez, who has set the tone or the mood for the discussion today. I don't have any slides, but I will be sharing some information about what's going on in Malaysia and the Malaysian experience, rather, or the Malaysian story of how the death penalty is looked at now and how we are dealing with it. So we do know that in Malaysia there are 33 offences that warrant the death penalty, of which 11 are the mandatory death sentence, and 22 are death sentences if meted out by the courts. So we're looking at 33 in total. However, as we know, after 2018, with the change of government, Pakatan Harapan was committed to abolish the death penalty, but we took into account a lot of feedback, opinions and views, and thought, let's start with baby steps, but in the right direction, which was to abolish the mandatory death penalty first. So there are 9 offences from the Penal Code and 2 from the Firearms Act that make up the mandatory death penalties in Malaysia. I don't have statistics to date up to October, but I do have, as of June 30th, 2020, we have 1,314 inmates on death row. 775 of them are Malaysians, 539 of them are non-Malaysians, of which in total 1,182 of them are male and 132 female. And as I have looked at statistics and answers given in Parliament, research done by the Death Penalty Project, research done by Amnesty International, research done by Penang Institute, research done by ADPAN, and also individual champions on the abolition of the death penalty, has shown that more than 80% of people or inmates on death row in the Malaysian prison come from the B40 category, which are primarily people who belong to the lower socio-economic rung in the country. They are the jobless, odd job workers, factory workers, bus drivers, taxi drivers, the ones who run small businesses. They make up the bulk of inmates on death row. And I think that should give us already a view of what kind of people who are on death row. And for me, my own personal experience was a few years ago when we were at a candlelight vigil outside Kajang prison, and this was on the murder that took place in Negeri Sembilan estate in Malaysia, where two brothers were charged with the murder and who were serving death row. A few of us gathered outside the prison. It was drizzling. It was a candlelight vigil. We were with their families, and normally in Malaysia, executions happen on Fridays, but it was a Wednesday. We heard that both these brothers could be possibly executed on a Wednesday, and it was a Tuesday night when we gathered. And what surprised me and hit me so hard was when I looked at the family of the brothers, and I looked at the cars that were parked by the roadside in front of the prison. You would see these locally produced Malaysian cars, your Myvi, your Perodua, your Kancil. And it hit me hard because you would not see BMWs or Mercedes-Benz, Volvos, Jaguars, or four-wheel drives parked by the roadside of a prison where the family members are pleading to the government not to free their children or their sons, but rather for the government not to execute them. Now, I'm a firm believer that if a crime is committed, then you must pay for it. And by that, it is not through means of execution. And it hit me hard because you would never see the family of CEOs, or managing directors, or men or women who are high up in society, or who have very strong cables, or who are high up, maybe even in government, who hold high positions in the society, who would be standing by the roadside and asking the government, or pleading to the government, please don't execute my children. And it dawned upon me that it was bigger than the death penalty itself. We're looking at an unequal situation where social injustice screams out louder than the call to abolish the death penalty. After the change of government, Pakatan Harapan, and I must mention here that we've also lost one of our strongest allies who was in the government before, Datuk V.K. Liew, who was the first person to announce that Malaysia was going to abolish the death penalty. He passed away last week, and it was shocking, not just to Malaysians, but also I received condolence messages from the PGA, from ECPM, and from the Bar Council, from Suhakam, from Amnesty, and friends who have been working on this subject for the past few years. So I'd like to actually dedicate this webinar that we're having in honor of Datuk V.K. Liew, and remind my government now that despite the change of regime, that things like this must be followed through. The right to life, as enshrined in the Federal Constitution in Malaysia, must be adhered to, respected, defended, and protected. Having said that, Datuk V.K. Liew was also the man who signed a moratorium on executions in Malaysia. So we have this moratorium now. There have been no executions from the time Pakatan Harapan became government until the change of government this year, end of February into early March. There have been no executions in the country because we still have this moratorium, which is important for the current government to see it through without lifting it. But I'd like to come back to a very interesting study that was conducted by Penang Institute. It was actually conducted between the period of 2013 to 2018, 5 years. I don't have any updated study if they have ever conducted any, but I think this should give us a rough view of or framework of what is actually happening on the ground. So Penang Institute is a think tank that's based in Penang, and they actually conducted this research, getting information and statistics from the Malaysian Legal Journal, the Current Law Journal, and the ASEAN Legal Information Portal, where they out of 289 cases that were studied, more than 27.7% of High Court cases were overturned by the Court of Appeal. And that means that's 80 out of the 289. The Federal Court overturned judgment for 10 of the 20 cases heard at Court of Appeal. 22.6% of murder cases of the 289, and 34.7% of the High Court decisions were revised in the Court of Appeal. So I think this is important because it shows that these are actually alarming numbers that shows that cases, especially particularly drug-related and murder cases, which warrant the death penalty in Malaysia, have had decisions overturned in court. And the reasons given for this overturn of decisions were 29% were because of evidence, 14.3% because of technicalities, and 7.7% a combination of both evidence and technicalities. And for murder, judicial errors in the Court of Appeal were higher amongst Malays. However, Chinese and Indians in Malaysia had 10% lower chances of having decisions overturned. So this is actually also very unique to look at if you want to look at, because Malaysia, we have it's a melting pot of race and religion and backgrounds and etc. And you find that even the way decisions are made in court, the way sentences are meted out, there is an injustice there as well. This is not my platform to take a swipe at court decisions in Malaysia. Neither is it my platform to insult learned judges and lawyers who are fighting cases. But I think this is something that we need to look at, particularly lawmakers in Malaysia, including the law minister, I hope, and the Attorney General. And again, the death penalty is a subject that is not very popular and only becomes popular, it only becomes hot news, it only becomes relevant to the man on the street if he is the one who is facing the death penalty, he has family members who are facing it, or he knows somebody who has been wrongly accused and the sentence is the death penalty. Until and unless it happens to someone or you have your own personal experience, it is normally regarded as something, you know, that, okay, this is what the government needs to do to counter crime, and it's a government's way of telling the people, the rakyat, you know, that this is how we would punish you if you commit a crime in the country. But let's also not forget that over the years, there's been an increase in number of Malaysians and non-Malaysians on death row in Malaysia. You know, significantly more than 30% increase of the number of inmates on death row. And I think that shows that, number one, the death penalty is clearly not a deterrent. Something is seriously wrong in the way cases are brought to court and how they are actually argued out, etc. There have been incidences of racial profiling, and also given the fact that I mentioned just now, more than 80% of inmates on death row fall into the category of very low on the socio-economic rung, which means their access to good lawyers or access to justice rather. I think access to justice is a very big word, but the fact that for them to know what their rights are, who should they meet first, you know, how are they questioned, and how are the witnesses surrounding the case, how were they questioned, the evidence, the you know, everything else in the outer circle of how the case is actually managed and investigated is extremely vague to the man on the street who doesn't know his rights. And that sort of access to justice is the thing that is worrying now. And especially at a moment where we're dealing with this pandemic and everyone's attention is there. I thank the many people who have retweeted this event, and also the opinions that have come either through Twitter and other social media platforms telling me, don't we have other important things to talk about other than the death penalty? Well, to set the record straight, tomorrow is 10th of October is the World Day Against the Death Penalty. And it is timely to talk about this subject now. Yes, there are very, very important things to talk about, like vaccine and social distancing and the economy and moratoriums. And of course, the general health of people in Malaysia and Southeast Asia, in the ASEAN region, in the world. But we're talking about justice. And we're talking about access to justice, and it may not be the death penalty today, but in this this is an issue that must be addressed in Malaysia, and I think this will probably make its way to BBC in the days to come, is the gross double standard that has been practiced by the government on lay people found to have been flouting SOPs or quarantines after their travels, including traveling from Sabah, which just recently saw state elections being held there, and how VIPs are let off the hook. So if you can have such glaring double standards of how ministers, deputy ministers, and VIPs are treated at a time of a pandemic and a time of heightened anxiety and concern and a phobia of whether it's migrants or refugees, then what about people who whether they have committed these crimes that warrant the death penalty? How do we ensure that their voices are not drowned by those who want to settle cases fast, who want to wrap up cases early, those who are afraid? And these are genuine fears, and these are real fears of police officers, and genuine fears of prison wardens, and genuine fears of those who are in court, and genuine fears of the public prosecutors when they are in contact with prisoners, when they're in contact with the public, etc. And these things will then, you know, affect and influence the way and how these cases would be heard. And it is particularly disturbing that in the first leg of the pandemic, unfortunately, Nigeria, I read, was, I believe, the first country to have meted out a death sentence via Zoom. And it was scary because Singapore was the next that I read. And Singapore is just, Singapore is a neighbor to Malaysia, and it was a fear whether it would soon catch on amongst courts and lawyers and attorney generals and public prosecutors and judges all over the world that, hey, you know, this would be a great way for us to save time, save money, save energy, and to protect ourselves when we fight a case out in court or virtual court. You know, so it was actually quite scary, and the matter was raised within my fellow colleagues and MPs within the PGA, and a statement was issued. But again, how do we make the subject of the death penalty and access to justice and access to legal representation a mainstream subject now when everyone is talking about bread and butter issues during this pandemic? And also of late, and this is something interesting, that we see more women becoming drug mules in Asia, particularly in Southeast Asia. More and more women are taking up places in prisons, and that is very, very concerning, because ASEAN is actually very, you know, have been very committed to eradicating the drug trade, the transboundary drug trade, especially in the you know, Bermuda Triangle of Laos, Thailand, and Vietnam, if I'm not mistaken. But apart from that, the Philippines, Malaysia, Indonesia, we all have our own crosses to carry when we speak about trying to deal with the drug trade, which in all these countries also warrant the death penalty, which is very scary. And you have, on one hand, more women who are becoming drug mules, and on the other hand, the government is being really tough on the drug trade, and the easy way out is to you know, close these files very easily and charge these women. You know, very rare you hear drug lords actually being the people who are apprehended, or, you know, whether how far and how deep are we going to follow the money trail to get the real culprits behind the drug lords, the kingpins behind the drug trade. So that's quite concerning for me as well, the number of women who are on death row or who are in prisons in Southeast Asia. I would like to wrap up my sharing today, and I hope it has been relevant to the topic, by speaking about, I think for those who already know, on Maindan. Maindan is a Malaysian who this year would be his 16th year on death row. He was charged with murder, and the greatest irony and the shocking aspect of his case is that the person he's been charged with murdering is still alive. So Maindan Maindan and Maindan's family come from a place in Kuala Lumpur where they also fall very low on the socio-economic category in the country. Maindan's wife earns well below the minimum wage. She has children who are in school, in university, who are studying in college, and it's very difficult for a single parent like Maindan's wife to raise her children in that kind of an environment. And again, if Maindan was a millionaire, if Maindan was a person who had the luxury of finding a high-profile lawyer, someone who would probably charge him hundreds and thousands of ringgit to be able to fight his case, will Maindan still be in prison serving death row? So it is this kind of a social injustice as well that sort of paves way for people like Maindan to be a victim of the system. I've always believed firmly that governments should be fighting crime instead of ending lives. And it's so ironic that abolishing the death penalty is often used as a trump card, no pun intended there, for governments to use as whether the boogeyman or the dark horse or the lottery ticket in any election, whether it's in a presidential election or whether it's in a general election in the country. The topic of the death penalty often comes up, it rears its ugly head. It is normally always, made as the boogeyman to frighten and instill fear in the hearts of the people that if there's a change of regime, then this government is going to abolish the death penalty. And that view for the man on the street is that, you would have criminals and murderers and drug traffickers, terrorists walking amongst you, living in your neighborhood and where you stay. And that just creates a unwarranted fear. And it's so funny because governments instead should be focusing on the right to life, rather than focusing on advocating for the death penalty. I've always asked this question: if Malaysia never had the death penalty, then how do we go about certain quarters or parties who say, oh, don't worry, we would counter and combat crime by introducing the death penalty? And how would then Malaysians react to it? Countries that have never had it or have probably abolished it years and years ago, how would then play out? How would it play out? But unfortunately, we do have the death penalty, and we've seen the numbers are rising. 1314 isn't a number that I'm proud of to say, and being a lawmaker, it's not easy. Many lawmakers don't take up the subject even, which is very understandable, because if the man on the street, your rakyat, the people, your voters are not given adequate information about why it's important to end or abolish the death penalty, then the reaction is very emotional, and it's always very visual as well. And the media plays an important role. And it's quite ironic because over the past 1 week, I've noticed so many death sentences meted out on cases that have happened 2 years back, 3 years back. This past 1 week has been, men raping children, children dying at the hands of their rapists, and the death sentence is meted out this week. Husband and wife abusing their children to the point of killing them, the death sentence was meted out this week. So I wonder whether it is in the days before we celebrate the World Day Against the Death Penalty. But the media plays an extremely important role on how a society or community, a nation, how voters view something so important like this. Again, I was like everyone else, 20 years ago, 30 years ago, I believed in the idea of an eye for an eye. If you harm somebody in my family, I would want the same thing to happen to you. So I understand when everyone says, how could we allow this to happen? How can you fight for these inmates who have done this and who are criminals and who are cold-blooded, who are monsters and animals? But I speak as a lawmaker today, and I know that if anybody can guarantee me that there will be no miscarriage of justice, which nobody can, then I cannot be a part of a system that is going to execute people because there are evidently flaws in the system. If you don't address social injustice, if you don't address poverty, if you don't address a strong social society, if you don't address strong family values, if you don't address inequality, then it is a crime for governments to be executing people. So yes, so that is my conclusion in this sharing here. Thank you.
Thank you, Kasturi. We'll be opening the floor to questions and comments and all that. We already have one from Honorable Ibtisam Azawi, who unfortunately had to, she was disconnected, so she's no longer with us. But she wrote to say, thank you for organizing this interesting webinar. How can we contribute through PGA to help abolishing the death penalty in Africa? So, Kasturi, I know you're not necessarily a specialist on Africa, but you're a specialist on PGA, so maybe you want to take that one.
Thank you, Marian. I'm sorry, what was the name of the MP who
Ibtisam Azawi. She's from Morocco.
Well, Morocco. So Morocco still has the death penalty, yes, but I was privileged to meet whether he was a former judge or a current sitting judge from Morocco in Brussels last year when we attended the Congress, the World Congress Against the Death Penalty. And it was refreshing to hear his views on the death penalty coming from an Islamic country like Morocco. From my conversation, my short, brief conversation with him, and this actually gave me a lot of inspiration and an idea as well, because I believe the royalty, the monarchy in Morocco believes in the right to life. And I think that's very, very important for the government, the executive to take note of. I think it is important if in Morocco you already have a Parliamentarians for Global Action chapter, then it is extremely crucial, very helpful to reach out to the PGA to be able to conduct a roundtable discussion as what had been done in Malaysia over the past few years, and to engage with local human rights organizations in Morocco as well. If the issue of religion comes up, then reaching out to religious leaders, the imams, the muftis in Morocco, as like in Malaysia as well, would be crucial as well, so that this conversation on the right to life, on the death penalty, can also be spoken about at interreligious dialogues and interreligious platforms as well. And I find it so interesting that countries whose laws are based on religious laws, we're talking about like non-circular countries that have religion in their civil laws or in their Sharia laws or other laws in their canon laws in their countries, for example, some of these countries still have the death penalty. And if you believe for these countries that are countries that are based on faith and religion, that if you believe that God gives, then you must believe that only God can take. And for these countries to have the death penalty it's ironic, if you believe in this kind of teachings and values of faith. So in the case of Morocco, you can send me an email. I'll be very happy to communicate with you how we have actually spoken about the death penalty in the Malaysian Parliament, how we have also engaged with civil society. Your national human rights institutions, very instrumental to engage with. They can be mediators between the public and also the government, the legislators and the executive. And I think if you want to conduct polls in your country, then a proper well-tailored poll or a set of questions is very important. And I learned this from a learned lecturer from Japan who shared this with us in Oslo at also one of the World Congress Against the Death Penalty, that questions on the death penalty cannot be a yes or no sort of a question without follow-up questions related to your answer. It's not as simple as asking you whether you like strawberry ice cream or chocolate ice cream. It's not a question of, do you support the death penalty, yes or no? Do you believe in an eye for an eye, yes or no? Now, these are all questions that cannot produce good answers for a government to decide. And again, I don't believe there are any governments that have approached its public or the people to ask them, we're planning to introduce new taxes on y'all. Do you agree with it or not? We're going to conduct a poll. And if majority of the people disagreed and said, no, you cannot tax us because we're already taxed too much, and the government is going to say, okay, we're going to listen to the public and say, call off the idea of taxing them. No government has engaged on something like this with the people and decided not to go ahead with taxes because the general public disagreed with it. You learn to adjust, and governments then justify why these taxes are imposed. But when it comes to the death penalty, it's so funny because it's always the government wanting to hear what the public sentiment is on the death penalty. And if the public says yes, they say, okay, we'll listen to public sentiment. And if this public says no, they say, okay, we'll go with public sentiment. But also let me remind that no single government on earth has ever received public support when they said they were going to abolish the death penalty. None. Even the most social democratic, the most advanced country, the country that believes and respects human rights and all that, have either a history of death penalty in their countries before they abolished it, much to opposition from the people, but it is the right thing to do. These are the governments that don't want to have blood on their hands, who view the death penalty as an issue of not just the death penalty, but of social justice as well. So to my colleague in Morocco, I'm in solidarity with you. I have a fellow friend in Morocco, a partner, that we can work together, because Malaysia is also at a crossroad on the abolition of the death penalty. We can share notes and experiences, and having Islam as the religion of the Federation, and also in Morocco as well, I think it's interesting for us to embark on the discussion on religion as well, and the death penalty in between Malaysia and Morocco. Thank you.
I will definitely put you in touch with Ibtisam. Parvez, do you want to add something?
Yeah, thank you, Marion. Just to add to what Kasturi was saying, I think if we're talking about abolition and how countries can move forward, it's important to say that very few countries abolish the death penalty through legal action. There are examples like South Africa and others, but very few. So abolition of the death penalty in reality is only going to happen through legislative change. So the role of the PGA, the role of institutions like that, and parliamentarians themselves is really, really important. I think what is clear in the countries that we've worked in is the importance of trying to engage with parliamentarians. And obviously, it's not just the message, but it's also who's giving the message. So the role that parliamentarians involved in the PGA, for example, speaking to other parliamentarians in other jurisdictions, I think is a very important method to have those discussions. I do think it's important to continue to highlight the issue of wrongful convictions and the risk that there are miscarriages of justice, because ultimately this is the issue. This is an important issue, and this is probably one of the most important issues to help bring about abolition. For example, in the United Kingdom, our own experience on abolition really came out of the unease from the number of wrongful convictions and executions that were taking place. And parliamentarians themselves decided that the death penalty had to be abolished and replaced. So I think it's very important to continue that engagement. It's also very important to engage with local stakeholders and actors, NGOs who are doing this work, and feel that so that they can feel they have support from parliamentarians in the work that they're doing. And I think Kasturi mentioned the role of the media. You know, people think of the media as just a medium for reporting the news. They actually strongly help shape opinion. So I think trying to engage with the media and ensuring that there is a good message that comes across through the media, and that they take their role very seriously in educating the public is a very important step towards creating that framework to allow a discussion to take place around abolition. And certainly from our own experience, we have been working in Zimbabwe for the last 5-6 years. Zimbabwe is a country that hasn't executed for over 15 years. It has a president that says he doesn't believe in the death penalty and it should be abolished. But yet the death penalty has not yet been abolished. There has been debates in Parliament from the opposition and from government talking about moving away from the death penalty. So even in a situation like that, where you have empirical evidence and research showing that the public don't overwhelmingly support the continued use of the death penalty, where key opinion influencers are saying the death penalty should be abolished, the president is saying the death penalty should be abolished, it's still not happening. So the question to ask is why? And it's really about that movement and taking the final step, whether it's a big hurdle or whether it requires strong leadership. So I think the role of PGA and organizations like yours in engaging and having those discussions is really, really important, because it doesn't just happen. Normally it doesn't happen in just one fell swoop. It's an incremental approach. It's a step-by-step approach. So I think engaging in that way is very, very important.
Okay. Any more questions, Marianne?
Marilina wanted to make a quick comment.
Okay, so I would like to invite Marilina Samuel, who is the ECPM Africa Asia Project Coordinator. I met Marilina when we were in Brussels last year at the World Congress Against the Death Penalty, and has been instrumental in arranging for meetings, comments, statements between us here in Malaysia. And I think the last conversation I had or discussion with Marilina was the team from ECPM, the President Ellen Movan and Rafael were on their way to visit a French national who was on death row in Indonesia, and they made a pit stop in Malaysia. And it just so happened that there was a roundtable discussion that was held in Parliament at that time in November last year, which had the team that was appointed by the Prime Minister's Department at that time, headed by Datuk BKU, Minister in Prime Minister's Department, where they were going around to collect opinions and views, and then finally at the end to present it to the government on the move to abolish the mandatory death penalty. So it gives me great pleasure to present Marilina Samuel. The floor is yours. How are you doing?
Thank you. Can you hear me?
Yes.
Yes. Hello, everyone. I'm very happy about this event. It's been very interesting, and I'll be quick in what I wanted to say. So yeah, I just wanted to add a bit on the work that ECPM also does with parliamentarians and other actors. We worked we've been working with PGA in Malaysia. We still go on with our work with MPs in Malaysia as we're doing in other countries. We usually try to form networks of parliamentarians. So in some countries it's easier than in others due to contexts and events. But for example, in Africa, we've been more successful than expected, because some networks have seen light. So we started in Morocco in 2013 or 15 to have our network of parliamentarians against the death penalty there. And since then, we've been working a bit in Tunisia, but more recently, we have a very active network now in the DRC, which was there for a few years, but with the game of elections, some MPs left the network. But since December 2019, we have a new chair lady, Honorable Christelle Bwanga, who is very active. And thanks to her, we have now a network that counts about 50 members, which is a very interesting, well, very impressive number because of the short time and also with COVID. But she's been very involved in the work for the abolition of the death penalty. And she's been advocating a lot with other MPs in Parliament, and also she created this action during the big crisis of COVID in the DRC, where she, with CPJ, so our partner in Kinshasa, and Iccpr, she organized an action to go to see the death row prisoners in the two prisons in Kinshasa. And she delivered there COVID kits, if I can call them like that, for the survival of death row prisoners, because some NGOs were providing help to prisoners, but not to death row prisoners. So once again, death row prisoners were stigmatized and they were not helped. So she took that opportunity as being the chair lady of that network to go to the prisons of Ndolo and provide all these kits and help death row prisoners. That was the occasion also for some interviews to be done and articles. So she gave light on that network. And so that's an example of work that we're having with them. We're organizing follow-up meetings with them, and now there's a proposal at the Parliament for the abolition of the death penalty. So we are working, well, they are working mostly to try to support it and to gather a bigger voice and more people to support that bill. There's also in Cameroon where we are working, where there a few years ago it was very hard to talk about the death penalty in Parliament. And now, thanks to one or two MPs who really wanted to make that topic a very important topic at the Parliament, it's still very small. It's starting, but it's something that didn't happen before last year because it wasn't possible. But thanks to the will of one particular MP, that there's a very small network of parliamentarians against the death penalty in Cameroon now. So no matter how small it starts, from the moment it starts, then the seed is planted. So more MPs can come. It's also important to work with political parties, because MPs can come and go, but political parties are the ones that stay. So if that's in the time of references, or I don't know, in the values, in the core values of the political party, it really helps in our work with MPs. And as Parvez was saying too, it's important to mix different actors, not just to work with one type of actor on the side and then with others. It's important to be able to work with the civil society, with lawyers, which we're going to do, and with MPs, and try to have platforms where they can share and see how one side of the landscape can help the other, because I think it's by joining forces that we can fight death penalty and go towards abolition. So that's what I wanted to say. Thank you very much.
Thank you, Marilina. And I think if I may, Kasturi, what Marilina said about starting small sometimes in countries where it's really difficult to talk about the death penalty, that's why having a network of MPs that is broader than the country is very helpful, because that means that Yes, it's hard to talk about the death penalty in Cameroon, but maybe the MPs from Cameroon, they can receive the support and benefit from the experience of MPs from another country where it might be a bit easier, where they might have the same type of problems that are used to justify use of capital punishment, and thus support each other in that way. And that's, I think, the added value of PGA's work in that domain. I don't know, Castor, if you wanted to quickly say something before we give the floor to Margareta.
Yes, I hope this is a very timely webinar, not just because we have the World Day Against the Death Penalty celebrations tomorrow, 10th of October, but also at a time where we have in the Malaysian context, an increased number of outbreaks in prisons and in detention centers. That is also something that is very troubling for human rights activists in Malaysia. And also lawmakers have spoken up that we need to look into prison reforms as well. So I think this needs to be said. Sometimes when we speak about an issue so big like the death penalty, we forget to speak about the other issues like prison reforms that is, greatly linked to how prisoners are kept, how prisoners spend their days of their lives in prison as well. I thank the PGA for being a very, very supportive partner, personally to me and also to the Malaysian Parliament, for constantly also keeping us on our toes on our pledge to be ambassadors of justice, ambassadors of peace, ambassadors of human rights as well, and also to Iccpr. Over the years, we've had a series of roundtable discussions between the PGA and the Iccpr. Today, PGA is already becoming a household name in the Malaysian Parliament on the various campaigns that have been carried. And I look forward to more engagements. I hope in person. It is nice to meet up with friends from the PGA in the Malaysian Parliament again, or any other places in Malaysia or even in the world. But for now, we would have to stick to Zoom calls and webinars. And I also like to thank the Death Penalty Project also for being very, very supportive with data, with information, with every type and kind of support that the Death Penalty Project has given us. There isn't a time that I have written an article or spoken about the death penalty in Parliament that I have not referred to information by the Death Penalty Project, by PGA, by Iccpr, by Amnesty International, Suhakam, AdPen, and all others who have spoken about this subject. So thank you. And also, I would like to remind everyone who is listening or who have tuned in, tomorrow, Malaysian time, between 3 to 5, Amnesty International has also organized a webinar session on the death penalty, which is to talk to some of us who have been working on the death penalty, people like Shamini Darshini, former executive director of Amnesty International Malaysia, Angel, whose brother is on death row in Singapore. She would be also together with us. Chow Ying, I think she worked together with Penang Institute on producing this report on the data on how cases are overturned and clear evidence of miscarriage of justice in the Malaysian courts as well, which is understandable. So we would be on. So for those who are interested, you still have time. Please log on to the Amnesty International Malaysia website and then register there so that between 3 to 5 Malaysian time, you can be part of the discussion as well. And thank you, everyone, and see you all tomorrow.
Margareta, maybe if you want to say a few closing words for everyone.
Oh, thank you very much, Marion. And first of all, thank you so much, Parviz Jabaran, Kasturi Pato. It has been a true pleasure to listen to you and take part and listen to your experience and knowledge. But I must also say that I have really enjoyed to listen to the words expressed by the World Coalition Against the Death Penalty. I think it's so important in this world that have been raised several times to build networks. And that's what we do in PDA, and that's what we have done with the World Coalition. And this is the way to move forward, but also like PDA to have a program to work in a more transparent way, to work in with a methodology, and also have a plan how to do things. I think this is also crucial. But as most of all, members of PDA, we are parliamentarians. And this means that we have a constituency. And I think, just as Kasturi said, with the man or the woman on the road, to be able to speak with the citizens in our constituency and explain, and also to listen and try to break through if there is a resistance to get rid of, to permit the death penalty. But of course also the parliament. The parliament is a very important arena where we can work both as individual MPs, but also in our parties. Take part in debates, be active, use our possibility to write bills, put pressure on the government. I think for do all this, we need as parliamentarians also to be active with others, to change views, to change experience, change knowledge. And that's what we can do in PDA. And that's also what I appreciate very much with PDA. And I just say the work haven't ended. Remember the day tomorrow. Be active on Twitter and other social media or in the constituency. I know it's very difficult these days with the COVID-19, and it's most of all, of course, important to stay safe and healthy and not to spread anything around. But it has been a fantastic seminar. So thanks again, Parvaris and Kasturi, for your engagement. You are inspiring for all of us to listen to. Thank you.
Thank you.
If we don't have any further question or comment, I suggest that we just leave it at that, have lunch or dinner, depending on the time zone. And thank you all for attending this webinar, for taking the time out of your day to talk about this very important topic, which isn't necessarily seen as the priority right now. And I hope that everyone will be very active tomorrow to make sure that the governments that still are proponents of the death penalty hear this community that we have. Oh, Andrew says there's a question. I'm just going to give him the floor then. Andrew, do you have a question then before we leave? Last minute.
Yes, can you hear me?
Yes, we can.
Okay, so I did put the question in the Q&A box, but since you've given me the floor, I'll ask it orally. I mean, the question is directed to Kasturi, but maybe Parvez may also want to have an input. You know, every 2 years there is this vote in the UN General Assembly on the worldwide moratorium against the use of the death penalty. And in 2018, under the previous government, the Malaysian government then, for the first time, voted to support this moratorium because we had already announced our own moratorium. Now, of course, fast forward 2 years later, we are under a different government now whose position on the death penalty is not quite clear. So I'm wondering what could be done, whether Honorable Kasturi Pato and her parliamentary colleagues may want to engage, and maybe the international NGOs may also want to engage with the Malaysian government to try to see whether they would continue to support and vote in favor of this moratorium when it comes up for the vote later this year. Thank you for the opportunity to ask the question.
You're welcome.
May I?
Go ahead, Kasturi. It's for you.
For the
it's your
question.
Yeah.
So for the year, as you know, we've just recently had our Parliament sitting from July to August, end of August, and under the new government, all the dissolved and restructured again, so on human rights, on etc. But with the new government, all these select committees had been dissolved, and only in the last week of the last Parliament sitting in August, the Speaker had agreed to 8 select committees to be set up, one of which was civil liberties and constitutional rights, I think, and that is supposed to cover human. There was no gender committee, so we fought for one going to sit in these select committees, and we hope by the time Parliament convenes on the 2nd of November, which is also the budget, that we'll be able to know who are the MPs who are going to sit in the select committees, particularly the ones related to human rights, so we can bring this subject of the death penalty in the committee and get other MPs to talk about it. Alternatively, I agree with Andrew. I think perhaps like-minded MPs like me and other fellow colleagues could perhaps be the mediator or the bridge between international CSOs in Malaysia or not based in Malaysia, like the PGA, like Iccpr, or even the representative from the EU, to maybe have a dialogue with the Minister of Law, either webinar, or they could come to Parliament, and we could start this discussion on the moratorium. I don't believe there has been any conversation about the moratorium on a international level. Just on a domestic level, we are still reminding the minister, please don't lift the moratorium, even though we've heard some rumors and some stories from prisons that there could be executions next year, etc. We don't know that. We're not sure. I hope that it doesn't come to that. But I would definitely like to talk to Andrew in detail about this and see how we can strategize, seeing that we only have 3 months left till the end of the year, and to probably include Suhakam in as well, the National Human Rights Institution, so we can expand the Bar Council, you know, all the stakeholders in to be able to give expert opinion and advice to the government on the right thing to do.
Marion, can I just
Yes, of course.
thanks, Andrew. I mean, it's an important question, and I think that the first thing, obviously the very first thing to do is to, as Kasturi says, is first to ascertain what the current government's position is going to be or is likely to be. I mean, I think in terms of the wider group and the wider institutions or individuals who may be able to bring or have some involvement, it's really important, I think, to address and emphasize the importance of international reputation. Malaysia has created a lot of credit for itself for the previous vote. It's created a lot of credit in the region for being a progressive mover on potential abolition of mandatory offences in terms of the moratorium and so on. So one of the things that you find about the UN moratorium is that countries very rarely, it's not impossible, but they very rarely take a backward step. So I think it's very important to try to explain to the government how important it is to maintain the position that they have now, and it would be a very alarming backward step. But I think the credit that has been created in doing what it has done previously, it's important to maintain that. So anything that we can do, both internationally and civil society and so on, to help Kasturi and others have that engagement, we'd be very, very happy to help.
Thank you.
Yeah, and of course the World Coalition is kind of making sure that every organization that wants to do advocacy and encourage countries, states to vote in favor of the resolution is working together. So we have kind of a work behind the scene to make sure that on every country where there is a chance to make a positive change, or where we need to make sure that the position that was held previously is still held this year, we are working with our many partners, so Amnesty International, the World Coalition, obviously, Iccpr, WCADP, a lot of organizations are working on this, and with local partners in each and every country, and with MPs to PGA, to make sure that from every angle, from the diplomatic representations in the countries, from the diplomatic representations in New York, from the MPs, from the NGOs, everyone has the same message, which is you need to vote in favor of the resolution, you need to co-sponsor the resolution if you can, or you need to abstain if you are not going to vote for every position that we think could be helpful compared to last time, to make sure that every time the resolution is adopted, it's with more states voting in favor. So that work is being done, and I'm sure that Andrew will be involved in the work that is being done on Malaysia in particular. If there are no other questions this time, I will just thank everyone again, and then encourage everyone to be as active as possible tomorrow to mark World Day Against the Death Penalty, and make sure that our abolitionist voice is heard by everyone that needs to hear it. And thank you once again for attending this webinar. I hope it was interesting and useful for everyone.
Marianne will be able to share the recording and also the slides, yeah?
Yes, so the recording will be uploaded on our YouTube channel whenever my colleague gets around to do that, and then I'll send the link around so that you can share it with your networks and colleagues. Okay, thank you everyone.
Also to everyone, on October 11th is the International Day of the Girl Child. So happy International Day of the Girl Child on October 11th as well. Thanks, guys. Be safe.
Be safe, everyone.
Safe. Bye.